Welcome you all to lecture number 4 of family law. Okay, this is part of Clat lecture series sponsored by Sri Jendra Rank Zone. I am your mentor Shekhar Gehlot. Okay, so we'll now proceed to another part of family law which deals with adoption. Now, I hope you all understand what is adoption. Becoming parents of a child who is not biologically born to you. This is called adoption. Okay, now I don't think that we have to discuss much over what is adoption. I hope you all understand what an adoption is and what is an adopted child or adoptive parent. Okay, so now we are done with the definition of adoption. Let us see what Hindu law says about adoption. Hindu law allows adoption. Hindu law allows one to adopt. Okay, parents are allowed to adopt as per the Hindu law. A perfect adoption fulfills all conditions of adoption with regard to who can adopt, who can be adopted, and who can give an adoption. Now, these are conditions which we have to see. Okay, we allow adoption. Okay, but what kind of adoption is allowed? What kind of adoption is allowed? Okay, who can adopt? Who can be adopted? Or who can give adoption? These are some questions which are left to be answered. Okay, but our Hindu Adoption and Maintenance Act, it provides solution or answers to these problems as to who can adopt and adopt it. Let us read what law says about it. Only Hindus who fulfill certain criteria are eligible to adopt. Who is eligible to adopt? Only Hindus. Okay, because we are talking about Hindu Adoption and Maintenance Act. So only Hindus are allowed to maintain as per this law. Who fulfill certain eligible criteria. Okay, now that means there are criterias. What are the criterias? First, must be Hindu. First is he must be Hindu. He or she or the parents must be Hindu. Then there are other criterias as well for being eligible to take in adoption. Now, what are the other criterias? Let us see. Adoption by man. If the adoption of a child is happening by a man, if man is adopting a child, then what are the conditions a man has to fulfill in order to conduct a valid adoption? Okay, what conditions a man is supposed to fulfill? Adopters should not be a minor. Okay. First of all, a man who is adopting another child should not be a minor. Okay. That means only a person who is above 18 years, only a man who is above 18 years can take adoption. Okay, only a male who is above 18 years of age can be adoptive father. Plus, if unmarried man is adopting a daughter, he should be at least 21 years old. Okay. At least 21 years of age if he is going to adopt a daughter. If he is going to adopt a daughter and if he is unmarried. Okay. The adopter should have the capacity to provide for the adopted child. Okay, he should have the capacity. That means law will go into the financial condition of adopting parent while allowing adoption. Okay, so adoption will be allowed only to such parents or only to such male who is having financial capacity to provide for the child. Now, what is the financial capacity to provide for the child? It again depends on number of circumstances. Okay, you have to give a decent living to child, you have to give a leisure time to the child, you have to give entertainment to the child, you have to give medical expenses of the child, you have to bear the educational expenses of the child, you have to give food, clothing, entertainment, all these things. Okay, so if you have that money, then only you can adopt. It's if 1 you are in o'clock. Such a condition that you are not able to maintain yourself, then how would you maintain a child? Okay, so law will not give a right to adoption to someone who's not having financial capacity. Now there arises a question. Now here a legal question may be that is this discrimination are here we trying to make a discrimination between a rich and a poor person? Because we are allowing someone who's rich, who has financial capacity, he can take son, but if he can take a child, but if suppose other is poor, someone is poor and they also want a child, they cannot have a child anywhere else. Okay, they are not able to have their own child. Now they want the pleasure of a child, so being poor they cannot get a child. Now, what is the discrimination? Why law says so? Why only financial rich people can take? Why poor people are not allowed to take adoption? This is law says it is in the best interest of child. It is in the best interest of the child. Okay, because child requires a minimum amount of expense. If you cannot do that, the child's interest will ultimately suffer. If you are poor, then child's interest will suffer. If you are extremely poor, if you have no money, then you may use child illegally as well. One can make child labor, send in prostitution, etc. Because child is adoptive child, law has to be more careful, isn't it? Because the child is an adoptive child, law has to be more careful. So you may, a poor person may take a child in adoption and then use that child illegally. May force him to work in restaurant factories, or if there is a girl, he may sell her in the prostitution, or he may kill the child and sell off the kidneys and organs, something like this, and run away. So, in order to save the child from these issues, we do not allow a person who is not financially stable to take adoption. And this is not, we are not trying to make a discrimination between a rich and the poor here. It may appear so, but ultimately we are doing it only for the safe consideration of the child who is going to be in adoption. The child must be capable of being adopted. Okay, the child must be capable of being adopted. Now, which child is capable of being adopted? Suppose mother does not allow adoption. Mother says no, I will not give my child in adoption. Father says I am willing to give my child in adoption. Such child will not be capable of giving in adoption. Okay, so or child has attained certain age, something like this. We'll discuss this section later on. Okay, that who is capable of being adopted. Okay, so a child must be capable of being adopted. Men adopting should have the consent of their wives. If man is married and she is adopting a child, he should have a consent of the wife. Okay, I should rather say he must have the consent of the wife. Consent of the wife is mandatory, because if there is no consent of the wife and you are adopting, then wife will definitely not take care of the child and the child is going to suffer. So law says if both parents are agree, then only we will give in adoption. If one parent is not agree, we will not allow the child to be adopted. Only exception is if wife or wives are of unsound mind or have renounced the world or ceased to be Hindu. Only exceptions are if wife is of unsound mind, she cannot give a consent. If she has renounced the world, definitely when she has renounced the worldly order, okay, she has become sannyasi, she is going to jungle, then her consent doesn't make a difference. Why? Because she will ultimately not be there for the kid. Or if she ceases to be Hindu. When she ceases to be Hindu, she foregoes all the rights which are entitled to only Hindu. Only a Hindu wife has a right to be consulted. A wife which is not Hindu does not have a right to be consulted here in Hindu Adoption and Maintenance Act. Okay. If adopting a son, if you are adopting a son, the adopter should not directly have a son, grandson, or great grandson who are Hindus, either by relationship or adoption. If you are trying to adopt a son, then you should not already have another son, okay, or grandson or great grandson who are Hindus either by relationship or adoption. That means a person who is completely without a son, then only he can adopt a son. If he has a son, grandson, or great grandson, three generations down we are going, and they are Hindus, and they are your son either by relationship or you have adopted them, then also you cannot adopt a son. But if they cease to be Hindu, then you can adopt a son. If you have a son and son ceases to be a Hindu, then you can adopt a son, otherwise not. If adopting a daughter, the adopter should not have a living daughter or son's daughter who are Hindus, either by relationship or adoption. If you are trying to adopt a daughter, you should not be having a living daughter or daughter of your son, okay, who are Hindus, either by relationship or adoption. So these are the cases in which a man, if he wants to adopt, he can do so. Okay, these are the conditions the man will have to fulfill. Now let us see what are the conditions a woman or a woman has to fulfill in case she wishes to take in someone for adoption. Adoption by a woman. Special conditions applicable upon women for adoption. Okay, only unmarried Hindu women, widow, spinsters, and divorcees can legally adopt a son or daughter in adoption. Okay, who can adopt? Only unmarried Hindu woman, a woman who is not married. If she is married, now she is widow, husband has died, or she is a spinster. Okay, she is a spinster, another name for unmarried woman. Okay, or she is a divorcee. They only can legally adopt a woman or daughter in adoption. That means no right. A married woman have has no right to adopt in Hindu law. Okay, she has to be unmarried, widow, or divorcee. Then only she can adopt. She should be a major and of sound mind. Definitely, a minor cannot adopt. A married woman can adopt a child. A married woman cannot adopt a child. She can only give consent for her husband to adopt. If she wants to adopt, she has to adopt through her husband. Okay, if a married woman she wants to adopt, she'll have to adopt only through the husband. Husband will have to give consent. Husband will start the adoption process. Then only a child could be adopted. She herself is incapable to take adoption. Exception is when husband has ceased to be Hindu, has renounced the world, becomes sannyasi, or has been declared to be unsound mind by the competent court. Okay, but if these exceptions are there, like we discussed in the case of man as well, if these exceptions are there, then she can adopt, and even a husband can adopt without the consent of the wife if wife is also out of these categories. If adopting a son, if this woman who is unmarried, okay, or widow or a divorcee, she is adopting a son, the adopter should not already have a son, grandson, or great grandson who are Hindus either by relationship or adoption. Okay, this is a common condition for male as well as female that three children of son, any of them should not be alive. If they are present and they are Hindus, then you cannot have an adoption. But if they are not Hindus, then only you can take in adoption. Otherwise, you cannot. If adopting a girl, the adopter should not have a living daughter or son's daughter who are Hindus, either by relationship or adoption. Then also you cannot adopt. Okay. if a male, if a Hindu male is adopting a child, and there are more than one wife living in the household, okay, more than one wife living in the household, then the senior wife is classified as the legal mother of the adopted child. The senior most wife will be the legal mother of the adopted child. Okay, senior most wife. What is senior most wife? It depends upon from the date of marriage, okay, not from the age. Okay, where a widower or a bachelor adopts a child, any wife whom he subsequently marries shall be deemed to be a stepmother of the adopted child. Okay, so now when you are taking a child, when you are married and you are adopting a child, okay, then that woman, which is already your wife, she will become the legal mother. She will become legally the mother of the child. But if you are unmarried and or you are a widower and you take in adoption, you bring a son, and then later on you marry, then this woman will not become a legal mother. She will become legally only a stepmother. Okay, she will become only a stepmother or stepfather as the case may be. Okay. Where a widow or unmarried woman adopts a child, any husband whom she remarries subsequently shall be deemed to be the stepfather of the child. They will not become legally father or legal mothers. But in case if you are taking in an adoption when you are married, then the mother and father are going to be the legal parents. Otherwise, only step parents. Now, who can be adopted? Now, we discussed a situation here where the eligibility is that child must be capable of being adopted. Now, let us see who can be adopted as per the Hindu Maintenance and Adoption Act, Hindu Adoption and Maintenance Act. Qualification: a child must possess to be adopted. Now, if some child wants to be adopted, he must be qualified. Okay, now what are the qualifications for such child? Let us see. The adopted child can either be male or female. Okay, he can either be male or female, or now it can be, or it can also be. Earlier, Hindu law did not permit taking third gender as an adopted child, but now it is allowed. The adopted child must be Hindu. Okay, you cannot adopt a Muslim or a Christian. If you want to adopt a Muslim or a Christian child, then you have to first get the child converted to Hinduism. Okay, then only after that conversion you can take the child in adoption. Otherwise, not. Okay, adopted child must be Hindu. The adopted child should not be already adopted. One who has already been adopted cannot be given in adoption. Okay, a child can be adopted only once. Okay, a child can be adopted only once, not more than once. So, a child which is already adopted cannot be adopted again. The adopted child should be less than 16 years of age except when customs or usage allows. Okay, usually the adopted child should be less than 16 years of age. You are permitted to adopt a minor only. You cannot adopt a major adult person. But if the custom or usage allow, wherein you can adopt a major adult as well, then you can have it. But usually, if there is no such custom or usage in your community to adopt a adult person, then you will have to go by the law, and law says only a child which is below 16 years of age could be adopted. The adoptee needs to be unmarried. However, if the custom or usage of applicable parties allow, the adoptee can be married. Okay, adoptee means who is giving the adoption, who is giving the child. Okay, they have to be unmarried, but if customs or usage allows, the adoptee can be married. Okay, sorry, adoptee means son, adoptee son or daughter, one whom you are going to adopt. Okay, the child has to be unmarried. However, if custom usage allows, the child who is going to be adopted, a son or a daughter, she can be married as well. Now, these are the requirements of qualifications a child must possess to be adopted. That is why we call adoption of a child. Okay, because we allow only adoption of less than 16 years. If we allow adoption of more than 16 years, more than 18 years as well, then we'll call it qualifications a person. Okay, adoption of a person or a human, will not call it adoption of a child. We call it adoption of a child only because we permit adoption of only those who are below 16 years of age. But if some customs or usages allow adoptions of people who are below 16, sorry, above 18 or adults, then that can be done as well. Who can give an adoption? Section 9 of HAMA, Hindu Adoption and Maintenance Act, lists out persons capable of giving in adoption. Giving in adoption means you are giving the child to someone else. Okay, who can be one who can give in adoption? Father. At the first instance, only father has the right to give child in adoption. Okay, first instance, only father has the right to give child in adoption. However, consent of mother is essential, but you cannot do it. A father cannot give the child in adoption as and when he likes. Okay, or not as per his own choice. He must take the consent of the mother. It is essential, unless she has renounced the world or she has become unsound or ceased to be a Hindu. Mother. When can mother give an adoption? If father is dead, or if father has ceased to be Hindu, or has renounced the world, or is declared unsound by court, or he has died a civil death. Okay, the mother has right to give child in adoption. Guardian. When both father and mother are dead. When father is not there, mother is not there. Okay. Or father has renounced the world, mother has become Muslim. In these cases, guardian will come up. Or has ceased to be Hindu, has renounced the world, or is declared to be unsound mind by the court, or when parentage of child is not known, the guardian of child may give the child in adoption with the previous permission of the court to any person, including the guardian himself. So the guardian can definitely give an adoption, but father wants to give child in adoption. He requires consent of the mother only. He doesn't require permission of the court. Mother wants to give child in adoption. She does not require the permission of the court. But guardian, because he is not mother or the father, he requires a consent of the court because court says we will see to whom the adoption is being made because guardian is not naturally attached to the child as father and mother are, so he is not supposed to take care of the interest of the child. He may sell the child. Okay, he may give the child in prostitution or other, or he may do something wrong with the child. Okay, so when a guardian is appointed and he wishes to give an adoption, the adoption has to be certified by the court, otherwise the adoption will be invalid adoption and will not have any legal consequence. Okay. Okay, it shall be void, it shall be invalid. Even if the guardian himself wants to adopt, he shall take permission. Before granting permission to guardian to give in adoption or to take in the child as in adoption himself, the court shall be satisfied that the adoption will be for the welfare of the child. Okay, now we are done with the portion of adoption.